Hello entrepreneurs, it's Michael Mort with Argent Place Law, the law firm for entrepreneurs. Today I want to talk to you about percentage ownership. So it's fairly easy if you have a partner, you guys agree beforehand how much interest in the LLC each of you is going to have. Maybe one of them is a minority or a woman and you want to have that person have at least 51%. So you negotiate that ahead of time and you decide and you put that in your operating agreement how much each owner, what percentage each owner is going to have. But what if you want to start a company as by yourself? You would think that you would just have 100% ownership, and certainly you can do that. But we often counsel our clients who have a spouse or a sister or a parent that they should also include that person, that relative, or a trusted person, a friend maybe, with a minority ownership. Why would we do that? Suppose you start a company and it's going well and all of a sudden something happens and you become incapacitated and can't make decisions, or you, God forbid, die. What would happen then? Well, the company would have, if you actually pass away, the company has no the LLC would have no members anymore and might even be subject to dissolution by the state. Or if it's willed to if the ownership of the company is willed to somebody else, yes, that person would become the replacement owner. However, that would be tied up in probate. It might take a long time. In the meantime, the company can't be operated. The bank account can't be accessed by an owner. So we often suggest that an owner, a single member LLC, give partial ownership, like a minority interest, something like 10%, to a spouse or other relative. There is another way. You don't have to give away ownership. You could name someone else as a manager or a co-manager with yourself. You could have your spouse be a co-manager and have resolutions in the company so that in case of a catastrophe, this co-manager will have, say, signature access over the bank accounts. Either way is appropriate, but it's interesting to consider the possibility that you have a co-owner in your spouse. Now, the downside, of course, is a spouse or any other relative may become belligerent. They will have always access to your books. There may be adversity in which you decide you don't want them to have any say whatsoever in your company. Those are things to consider, but I want you to know that it's never a good idea to have just naked one-person ownership in a company with no backup to manage the operation in case of catastrophe. So I'm Michael Mort with Argent Place Law, the attorney for entrepreneurs. We're here looking out for you.